Good afternoon and welcome to today's webinar, Back to School, an immigration law update for the start of a new term with Adam Pipe from No.8 Chambers. Adam is a barrister specialising in immigration, asylum and human rights law and is ranked by Chambers and Partners for Immigration Law in the Midlands. Adam provides regular updates on the law at training events and on social media. For those of you who haven't joined our webinars before, my name is Finn and I'm a Junior Compliance Officer at DG Legal. The slides from our presentation today will be sent over tomorrow, and a recording of the webinar will be available for 3 months. So if we do run over or if you need to leave, you can watch the rest at a time of your choosing. We are in webinar mode, so we can't hear or see any of you. And this is a fast-paced webinar. And I know Adam has a lot to cover over the next hour, so I'm afraid we won't be able to cover any questions that you have today. Over to you, Adam.
Finn, thank you so much. And thanks to the DG legal team. Thank you for David and his team for putting this on today. We're back to school and the class is a big class today. I think there's over 830 people registered for today's webinar. So thank you for everyone who's coming to join me for class today. As Finn said, the webinar recording and slides are available. The link is there. They'll also be emailed out. So don't stress, you will get a copy of my slides. As usual, myself and DG Legal are doing this completely for free. There's no charge and I'm not charging DG for today. So do consider going on that top link and donating to one of DG Legal's chosen charities. There's about 3 great charities there, and if everybody donated a couple of quid, we could make a huge difference and a positive difference for today. And as I've said, today is being put on by DG Legal. Thank you to Finn and Savannah for their technical help today, and thank you for David for doing that. But if you need help with setting up a firm, with authorization, with accreditation, with GDPR, with compliance, or just increasing your client base, do reach out to DG Legal. I've put there a link to their services and see how they can help you in the future. Everybody knows me, so I'm going to jump over my link. But if you need to contact my clerks at No.8 Chambers, I obviously cover immigration law across the country. Do click on that link, reach out to my clerks at No.8 Chambers. In terms of my free resources, as I've said in previous webinars, get your phone out now and scan that QR code. My latest YouTube videos are there, including a discussion I had with Shara Pledger about some issues with the new skilled worker route. If you haven't watched that, and the sort of interplay between the skilled worker route and employment law considerations, Shara brings up some really helpful points. If you just want to sign up for my WhatsApp or Telegram channel, that's the quickest free way to get information from me. I've literally just posted something about a minute or two ago on those channels. So do sign up to those channels if you just want to connect via LinkedIn. And as Finn said, today's going to be quite fast moving. There won't be chance for questions or discussion. So if you want to have time where you can go through these changes in a sort of slower pace, to discuss things, to have chance to network with other practitioners, I'm putting on some live events throughout the country in Birmingham, Manchester and London, and links to sign up for those events are also available through this QR code. So it'd be lovely to see you where we can talk through these issues and answer some more questions. So, as you know, over recent months, nothing's been happening in immigration law. It's been a completely quiet time with no major changes or anything like that. Well, actually, the truth is the complete opposite. We've seen massive changes. And in fact, we're due another statement of changes today. Probably by the time I've done this webinar, the new statement of changes in relation to family reunion pausing of applications will be out. But let's have a look first at some of the news items and what's been proposed. We'll have a look at the white paper and the statement of changes, and then we'll cover some key case law, and I'll give you some headlines from the case law development. So this is the story that first was in the Sunday Times. This is a news item from EIN. If you don't follow EIN's news section, do that. That's not just for subscribers. That's free to everyone and is a brilliant source of news, and it'll help you actually keep your own client base up to date. But Yvette Cooper announced a major overhaul of the immigration and asylum appeal process in this autumn, including a fast-track process for asylum seekers. Now, a lot of us will be pleased to see an overhaul, well, not an overhaul, but pleased to see some attention being given to the appeal system, because our clients have had huge delays, and practitioners like myself and any of you who appear in the tribunal will know a huge number of our cases have been adjourned recently because of a lack of judicial availability. So that's a positive thing. But what we're seeing, there are a few worrying things. There's this announcement, it's like going back to the past, of a new fast track system. And as you will know, the fast track system in the past was ultimately scrapped after the courts found it structurally unfair and unlawful. So there's some concerns about this move back to a fast track system. So here's the Home Office announcement, and it says this: a new independent body will be set up to speed up decision making on asylum appeal cases. The new body will be fully independent of government, with safeguards to ensure high standards, and is expected to use the expertise of independent, professionally trained adjudicators, focusing particularly on asylum appeals, and will allow capacity to be surged so cases can be cleared. It will have statutory powers to prioritise cases from those in asylum accommodation, so it's very much linked to clearing the sort of hotel issue, and foreign national offenders. And there's some statistics there giving the current backlog of 106,000 cases waiting to be heard in the FTT, including at least 51,000 asylum appeals with wait times on average at the moment of 53 weeks. Now, interesting, this talks about a new independent body. Well, we've got at the moment the Independent First Tier Tribunal, which is staffed by professionally trained immigration judges, tribunal judges. So I don't know, it's not clear if this new body is going to replace or sit alongside the FTT, because there seems to be a particular focus in this announcement on asylum appeals, particularly asylum appeals from those in asylum accommodation or foreign national offenders. And there's also talk of adjudicators. So we said earlier, fast track appeals was something in the past. Well, adjudicators was something of the past. When I started doing immigration appeals about 26 years ago, I appeared in front of an adjudicator. Now, are we going back to that? What happens to all the immigration judges? So it's not clear in relation to that. To relieve pressure on the system, the government has provided funding to increase the number of sitting days in the First Tier Tribunal, with the aim of ensuring it operates at maximum capacity. Well, that's a positive thing, because as I've said, we've seen huge waits and lots of last-minute adjournments. Ministers are also introducing a new legal requirement for a 24-week time frame for the First Tier Tribunal to determine asylum appeals by those receiving asylum accommodation support and appeals by foreign offenders. So that talks about a 24-week time frame in relation to the FTT. The government will set out further details of our plans for fast-track cases in the autumn. This is an announcement we saw yesterday, and again, it's what they call a crackdown on legal visa abuse. And what they're focusing on here is those who come on work, study, or visit visa routes and then claiming asylum, and a particular focus on, say, students claiming asylum. So they talk here about the crackdown, including record number of credibility issues and mandating a genuine study requirement for short-term student routes. And they also have launched a direct messaging campaign. So again, we've talked about fast track thing of the past. We talked to adjudicators a thing of the past. Well, we had under Theresa May the go home vans. Well, now we've got this direct messaging campaign to remind students their visas are expiring. I just noticed that the UK Council for International Student Affairs have put a notice on their website and a statement on the government announcement warning students not to overstay their student visa, and they're warning about claiming asylum. There's some really helpful stuff, and representatives may want to post this on your website or your social media. So I've just put on my WhatsApp channel and my Telegram channel the statement from the UK Council for International Student Affairs on this government announcement. So may want to have a look at that and make sure your client base is aware of that. The big announcement this week came on the 1st of September from the Home Secretary, and involved the suspension of new applications for refugee family reunion. Now, I was hoping we'd have the statement of changes by the time I had to send my slides to DG. Unfortunately, we haven't had them, but certainly ILPA let people know yesterday that they thought that from 3 p.m. today, the suspension was going to come into force. So certainly we're going to see that imminently, probably today, with all indications. But this is the statement from Yvette Cooper in relation to that, and it covers the suspension of refugee family reunion applications, but it also sets out some other matters. So again, and I've highlighted this on this slide, about the reform to the appeal system. And they said this: we've already funded thousands of additional sitting days this year, and the Border Security Bill will introduce a statutory time frame of 24 weeks. So there's that 24 weeks time frame going to be put into statute. And then again, we will introduce a new independent body to deal with immigration and asylum appeals. So that talks about immigration and asylum appeals. It will be fully independent of government and staffed by professionally trained adjudicators. So there's that again, with safeguards to ensure high standards. It'll be able to surge capacity as needed and to accelerate and prioritize cases alongside new procedures to tackle repeat applications and unnecessary delays. She also announced in this statement an increase in detention and returns capacity, including a 1,000-bed expansion at Campsfield and Haslar. So obviously this focus on detention and removal. Something we're going to look at when we come to the white paper is obviously that the government have indicated an intention to reform family migration and a particular focus on Article 8. So we're going to see changes this year in relation to Article 8, and we'll come back to that in a moment. So the immediate change the Secretary of State announced was this suspension of refugee family reunion applications, which is due to come into force, as I said, today. She talks about the timescales and the fact that Denmark and Sweden are not able to apply for family reunion for at least 2 years after protection has been granted. And she says that now, on average, it takes about a month after protection has been granted for somebody to apply for family reunion, often before they've left asylum accommodation. And she says, as a consequence, refugee families who arrive are far more likely to seek homelessness assistance. Currently, there are no conditions on family reunion for refugee sponsors, unlike those in place if the sponsor is a British citizen or long-term UK resident. That is not fair. Well, it's always been different. The family reunion rules haven't had a financial requirement because of the particular position of refugees and the importance of family reunion within the Refugee Convention. So what they propose is in their asylum policy statement later this year, they're going to set out a new system for family migration, including looking at contribution requirements, longer periods before newly granted refugees can apply, and dedicated controlled arrangements for unaccompanied children and those fleeing persecution who have family in the UK. Therefore, this week, and we think today, we're bringing forward new immigration rules to temporarily suspend new applications under the existing dedicated refugee family reunion route. Until the new framework is introduced, refugees will be covered by the same family migration rules and conditions as everyone else. So it looks like after the suspension comes in that interim period, refugees will have to then apply under Appendix FM until we see the new asylum policy statement. In terms of some positive things in the statement, there are two positive things. We will continue to do our bit to support Ukraine. So there's going to be an extension to the Ukraine Permission Extension Scheme by a further 24 months. And they're also looking to take immediate action to rescue children who've been seriously injured in the horrendous onslaught on civilians in Gaza so that they can get the health treatment they need. There's also in that paragraph about students from Gaza as well in the final paragraph. Let's look at some other news and then we'll come back to the white paper and then to the statements of changes we've seen so far. So there is a new British citizenship route that's been launched for Irish citizens. So an easier route. It's come into force on the 22nd of July. I'm not sure how many people it'll actually benefit, but it's 50% cheaper than other nationalities. They won't be have to demonstrate a knowledge of English language or sit the life in the UK test. So they'll need to show they've been living in the UK for the past 5 years, not been absent for a total of 450 days, during the final year not been absent more than 90 days, not in breach of immigration law during that 5 years, and be of good character. So a new, easier route for Irish citizens to become British. This is a positive announcement from the beginning of July this year in terms of an increase to immigration legal aid fees. So that's a positive thing, including an increase to the hourly rate and for fixed fees for immigration and asylum work, and the fixed fees for asylum legal help rising. So that's a positive development. Now, in February, the Supreme Court handed down its judgment in the N3 case, and that was about the effect of deprivation orders. And the implication of the ruling in N3 mean that if a deprivation appeal was allowed, that rendered an appellant British again, even though the Secretary of State may pursue an onward appeal to the higher courts. Now, the worry the Secretary of State had was that during an appeal, somebody might, say, renounce another nationality, so they could then argue statelessness potentially, or somebody that the Secretary of State didn't want back in the UK could travel back into the UK. So they've introduced the deprivation of citizenship orders effect during appeal bill to remedy this. And what that means is that things would stop then whilst an appeal is pending. So a deprivation order continues in effect during the entire appeal period, even if the first stage appeal is won. That doesn't alter the right of appeal, doesn't expand the reasons for deprivation, and it does not revise the retrospective reinstatement rule once appeals are fully exhausted if the appeal is successful. So I just want you to be aware of that change. There's also been an update to the long residence caseworker guidance for a lot of our clients. The long residence rule is the pot of gold at the end of the rainbow. So there's a change there, and it reflects the changes to the immigration rules that I'm going to come to in a moment. But it clarifies that time as a British citizen counting towards the qualifying period under the long residence provisions. And this is, of course, where somebody might renounce their British citizenship and apply under the long residence rule then. So it sets out the sequencing for an application for a renunciation with an application under long residence. It also reflects the changes to Appendix continuous residence in relation to time spent in the Crown dependencies, and we'll come back to that in the statement of changes. Now, all of these changes have their genesis in the white paper. I know a lot of you may have attended webinars I've done before where I've summarized the white paper, and a number of the reforms in the white paper have already come in with the recent statement of changes. But I just want to highlight the white paper before we look at the statement of changes, so you know what's come in and you know what's yet to come. So what I'm going to do is give you some key extracts, but I'm also going to interweave some of the recommendations from the Migration Advisory Committee's report on the minimum income requirement for the family migration route, because we had that in the summer. So that's something I can already talk about. So we see the government's aim is to restore confidence, as it says, in the immigration system, and they want to control migration, and they don't want it used as an alternative to fixing problems in the UK. So the headlines are set out in paragraph 27 to increase the threshold for skilled workers to graduate level, and we've already seen that happen. They want to only allow a narrow list of critical shortage occupations onto the temporary shortage list, alongside workforce strategies to increase training and participation rates in the UK. Well, we're sort of in an interim period at the moment. We've got the immigration shortage list and the temporary shortage, immigration salary list, and the temporary shortage list. And then from the beginning of 2027, we'll just have the temporary shortage list. Closing the social care visa route to overseas recruitment. Well, we've seen that come into force. Restricting dependence for lower skilled workers on the temporary shortage list, and increasing salary threshold for all visa holders seeking to bring dependents. We've seen that. Increasing English language requirements for visa holders and dependents. Well, that's on the way. So some key extracts then from the white paper. We're going to see an establishment of a labour market evidence group. And different sectors are going to have to produce a workforce strategy, and they'll be expected then to comply with that. Paragraph 68 talks about raising the level back to RQF 6 and above, and the rising of salary thresholds, or we can put a tick by that. We've seen it happen. And what's the implication of that? Paragraph 69, well, eligible occupations reducing by 180. Paragraph 70 talks about the immigration salary list being abolished. Well, it's not yet abolished. In fact, it's been expanded. And then ultimately, it will be replaced by the temporary shortage list. Paragraph 71 sets out the fact that there will be transitional provisions for those already in the skilled worker route. But obviously, new applicants or those trying to switch will have to follow the new rules. So for RQF 3 to 5, they'll only be permitted use of the points-based system on a time-limited basis where the MAC has advised it is justified and where this workforce strategy is in place. And they're going to do that through the temporary shortage list. Paragraph 81, we can put a tick by this. There's going to be an end to overseas recruitment for social care visas, but it's a transitional period until 2028, where there'll be a permit visa extensions and in-country switching, although there are requirements on those who can switch, and we'll come to that with the statement of changes. There is some positive news in relation to a proposal to have a displaced talent mobility scheme, but this is for a limited pool of UNHCR recognised refugees and displaced people, and the numbers are limited. There's the proposal to increase the immigration skills charge by 32%. Paragraph 89 sets out the positive developments where there's going to be expansion, but again, it's pretty small beer. So they're going to increase the number of people arriving on our very high talent route. As part of that, they're going to increase places on the government authorised exchange scheme, including those working in the field of AI, to allow businesses to access to additional promising young talent. They're going to make it simpler and easier for top scientific and design talent to use the global talent visa. They want to review the innovator founder visa, and they're talking about ensuring that it supports entrepreneurial talent currently studying at the UK universities to move into the innovator founder visa. They want to double the number of workers that an overseas business can send to the UK with an aim of establishing a presence in the UK. So that's the UK expansion worker, so it's doubling from 5 to 10. We will explore a targeted and capped, so limited there in the language, expansion of the high potential individual route, looking to double the number of qualifying institutions. Remember, you need to be a qualifying institution to qualify then under the HPI route. There's this crackdown in terms of international students and regulation of educational institutions, also on short-term students, talking about local impacts and review of accreditation bodies. And one of the big news, and this impacts not just students here, because the Russell Group have done a statement about this, but also employers who rely on those on graduate visas, is this reduction across the board in relation to graduate visas to 18 months. So at present, it's either 2 years or potentially 3 years, but a reduction to 18 months. And there's also exploring a levy on higher education provider income from international students. And as I've already trailed from the Home Secretary's statement earlier this week, they're looking at Article 8 because they're not happy with the number of cases that are treated as exceptional. Look at paragraph 147. So before the end of the year, we'll see a new family policy that seems to cover all UK residents, including those who are British, settled on work routes, or refugees seeking to bring family members to the United Kingdom. So I presume like a souped up version of what is now Appendix FM, have a clear relationship requirements. Again, they're addressing English language skills and they're addressing finances. Now, in relation to finances, we know they referred the matter to MAC. And as I've said, MAC have reported back in June of this year. And we'll come to that in the next slide. But they're exploring also tightening suitability rules on family routes. So we had the letter from Professor Brian Bell, it's in my hand, to the Secretary of State, and there was a report on the minimum income requirement. Because as you remember, the Conservatives wanted to tie the minimum income under the family route to the skilled worker route. So the aim was to increase it to 38,700. The initial rise was to 29,000. The Labour Party pressed pause and referred the matter to the Migration Advisory Committee. And in June of this year, MAC reported, and interestingly, they gave a number of options depending on what you want to calculate the minimum income requirement on, whether on a standard of living benefit, a basis, a benefits basis, a fiscal basis, or an average earnings. But what they propose, they say, when considering measures that focus on the family's ability to support itself financially, we suggest that reasonable measures fall in the range of 19,000 to 28,000 for the sponsor alone. A number of such measures based on different approaches, including working full-time at the national living wage, fall in the range of 23,000 to 25,000. So interestingly, their suggestions were not above the current 29,000. They're concerned about, look at the middle paragraph that starts our analysis, about British children who are currently separated from one of their parents, and they want to minimise that if possible. They also want to look at how the main applicant's income could be taken into account at the initial entry clearance stage. They were also concerned about the adequate maintenance test. So, you know, people who are on certain benefits, they can go down the adequate maintenance test, and they discuss alternative approaches to the adequate maintenance test, including having no financial test and just having an accommodation requirement for those who are subject to the adequate maintenance test. So here's some extracts from the report itself, and you'll see the various numbers that I've already quoted to you. They suggest it should be kept uniform. They don't recommend regional variations. They also don't recommend an additional amount for families with children. You know, under the old 18,600, we had the additional child element. With 29,000, it is a flat rate. They also think it should be a flat rate. And again, as I've pointed out, they were not convinced that the current system sufficiently takes into account the negative impacts of separation on British children. They're concerned that the adequacy of maintenance test, what they call the AM test, is incoherent and unnecessarily complex. And they think that effectively everyone who is subject to the adequacy of maintenance test will actually meet it. So maybe they should replace it with a more coherent calculation or just of housing suitability alone. They do not understand the rationale for trying to tie the minimum income requirement under the family route with the skilled worker salary threshold. And they do not recommend the approach based on the skilled worker salary threshold, as it is unrelated to the family route and is most likely to conflict with Article 8. As I've said, they recommend looking at options for the main applicant at the entry stage, including job offers. I've already addressed the issue about a separate child element, which they do not recommend. They're also concerned that this last increase, we had the 2012, the introduction of the 18,600, then it was effectively like 12 years later, it went up to 29,000. And they're recommending regular review so we don't have this huge unexpected increase. Let's get back to the white paper. I'm conscious of time. They're going to review Article 8 and they want to set out what they say is exceptional circumstances. We had in 2014 a new act that introduced the Article 8 section into statute in 117A to D, and we had those 117B, which applies to all cases, and 117C in deportation cases, but they want to define even more what is exceptional circumstances. And they're concerned about those, paragraph 154, who come on short-term visit visas and then try and stay on family basis, or perhaps have spurious claims to increase the likelihood of having an Article 8 claim upheld, or apply, as we've seen with the family reunion issue, for family members straight after particularly much arriving. So they want to bring forward legislation, paragraph 156, to strengthen the public interest in terms of Parliament setting where the balance lies, to clarify the Article 8 rules and set out how they should apply in different immigration routes, so fewer cases are treated as exceptional, set out when and how a person can genuinely make a claim on the basis of exceptional circumstances. So that's coming. If you've got clients that have applications that don't fit neatly within the rules and you're going to have to rely on sort of Article 8 and justifiably harsh exceptional circumstances, it may be worth making those applications sooner rather than later, because change is coming and tightening up is coming in this area. They've also addressed community sponsorship schemes. And in terms of workplace sponsors, they say this: we will therefore explore introducing further reforms to our sponsorship system, putting more responsibility and accountability on effective and responsible sponsors. And we've obviously seen a huge increase in sponsor license revocations. This will include exploring making it easier for workers to move between licensed sponsors for the duration of their visa, giving them more control over who they work for and reducing the risk of exploitation. Some tightening up on the sort of hostile environment in relation to banks and HMRC and etc. And then English language. So if you've got clients or if you work with sponsors who employ people, really worth focusing on English language because it's going up. So skilled workers and workers where a language requirement already applies from B1 to B2. For the first time, they're introducing a language requirement for all adult dependents of workers and students to level A1. And then introducing requirements to demonstrate progression to A2 at extension stage and B2 at settlement, and then increasing across the board the settlement requirement from B1 to B2. That's not yet enforced, but that's coming. And that change, I think, could come in quite quickly because I don't think there'd be pretty much consultation on that. And then something that's gained a lot of publicity, this whole idea of earned settlement and earned naturalization. So they're increasing the standard qualifying period for settlement to 10 years. Now, there's been a lot of questions about this. Will it be retrospective? How will it apply? Will there be transitional provisions? There has been a number of petitions, and I think this is going to be debated in Parliament. They do say we will continue to offer a shorter pathway to settlement for non-UK dependents of British citizens to 5 years. Interesting, it says British citizens, not British unsettled persons. And then there's this chance to reduce your qualifying period under the points-based system by contributing to the economy and society. So time to advise clients to do the charity work. There is going to be a creation of a new bereaved parent route. That's a positive thing, and some protection for children who turn 18 and haven't got status. But also this then earned citizenship idea and increasing the standard qualifying period. So that's also something to watch out for, and a refreshing of the life in the UK test. So that's the white paper. So what changes have we seen so far since then? Well, we had a positive statement of changes. Like they got all the positive stuff out, and then all the tough stuff comes afterwards. So this is the positive statement of changes, 836, which is on the 24th of June. This was the one that set out to clarify time as a British citizen is lawful presence under the appendix long residence, except where you've subsequently had your citizenship deprived. It also changes appendix continuous residence in terms of treating time with permission in the Crown dependencies, Isle of Man, Jersey and Guernsey, on a route equivalent to those in the UK as lawful presence. There's also the change, a welcome change to appendix private life. If you've seen my discussion with Denai on my YouTube channel, we previously discussed the issue with appendix private life and the problem with people having to have their last grant of leave under the private life route in early to access the earlier grant of settlement. And this was a problem because a lot of people were granted outside the rules or under appendix FM. Well, that has now been dealt with. Changes now being made to allow young people granted in the UK on the basis of their family or private life before 20th June 2022 to settle under the 5-year private life rules if they met the half the life test at the date of application or met it in a previous application. Changes are also being made to allow children who have lived in the UK for 7 years to qualify for settlement after 5 years. This cohort were not part of the concession. That was the concession that predated then appendix private life, but a 7-year qualifying period who applied as a part of a family group would always have been granted under the family rules and cannot currently qualify under the private life rules for settlement after 5 years. So that's changed then to make that available. So that's a positive thing. Look at, I think it's PL11 and PL14 in the private life rules. Then there's been a positive change in relation to the EUSS continuous qualifying period definition. It was no more than 6 months in any 12-month period. It's been simplified to simplify the assessment of continuous residence. These changes enabled a pre-settled status holder to be granted settled status where they've been resident in the UK for at least 30 months in total in the most recent 60-month period. This can be any 30 months within the 60-month period. There is a tightening up here in relation to refusals of applications or cancellation of permission mandatory for those excluded from asylum or humanitarian protection or non-refoulement. Straightforward there. And some other minor changes as well. So here's the big statement of changes we had on the 1st of July. This was the tightening up of the skilled worker route, the raising of the skill and salary floor, the restricting of low-skilled sponsorship, the care workers, and also the closure of ARAP to new principal Afghan applicants. Just some quick summary. So RQF level 6 has come in, removing 180 eligible occupations. There is transitional protection for existing visa holders or those with a certificate of sponsorship issued before 22nd of July 2025. So obviously they're valid for 3 months. So there still could be people who are making applications with causes issued before the 22nd of July. And transitional provisions I've highlighted there. But notice these transitional provisions will not be in place indefinitely and will be reviewed in due course, which is a constant theme they keep saying. Increasing of the salary threshold with no transitional protection. So general salary up to 41,700, PhD under option B up to 37,500, STEM PhD, ISL or new entrants up to 33,400. So there are no transitional arrangements relating to the update to salary requirements. So any new applicant needs to be on these levels, or when you're renewing, you need to make sure your salary is at the correct level. There is some guidance on salary levels given in the skilled worker caseworker guidance. I know this is very complex, even for those who do these applications day in, day out, which I as counsel do not, but do look at all that very carefully. And we have the temporary shortage list, which allows sponsorship in lower skilled occupations, but these are for causes issued before the 31st December 2026. Obviously, there'll be changes then when the TSL completely replaces the ISL, because the ISL continues and is in fact expanded at the moment, but there's no provision for dependents under those routes. The end of overseas care worker recruitment from the 22nd of July, but there is in-country switching up until 22nd of July 2028. Workers must have been legally working for the provider that is sponsoring them for at least 3 months before the date of their certificate of sponsorship was issued to them by their sponsor. So only those who are working for the provider for at least 3 months can then switch. There is a removal of that requirement to first try and recruit from a pool of skilled workers that was introduced back in April, because that's no longer relevant given the entry clearance applications. And then the closure of the Afghan relocation and assistance policy to new principal Afghan applications, but family members of those who already submitted principal applications may still apply. Then we've seen another statement of changes on the 5th of August this year. This was to introduce Appendix Appendix UK European Applicant Transfer Scheme. So this scheme will open for a time-limited application window and is restricted to those in France at the time. The scheme allows for adults and family groups of parents and children from all nationalities, bar a national of an EEA member state, or those who enjoy free movement rights as family members of an EEA national, to express an interest in coming to the UK. Those whose application is approved and who meet security checks will be able to come to the UK for 3 months to consider how to regularise their stay in the UK. And I've set out an extract there from the statement of changes about the 2-stage application process and the need for an expression of interest first, and how that is then considered. There's also links to the policy and the application form if you're advising anybody in relation to applying under this route. And there's a helpful article on EIN which goes through the caseworker guidance and the different stages and the different priorities they look at when deciding those applications, but you can have a look at those slides. So what have we done so far? We've looked at the news, we've looked at the background in the white paper, we've looked at the last 3 statement of changes, and finally in the last 15 minutes we'll just look at some case law. I've already talked about sponsor licenses and the increase in revocation. In previous webinars, we've talked about whether the Secretary of State has a duty to conduct a global assessment before revoking a sponsor license. And there have been conflicting case law. So 2 of those cases went to the Court of Appeal, joined Prestwick, which had said there was no duty of a global assessment, and Supporting Care, where the judge had found there should have been a global assessment. Well, the Court of Appeal in Prestwick agreed that there was no global assessment duty. So they found that Supporting Care was wrong in relation to that. But they did uphold Supporting Care and the quashing of the decision because they found that the Secretary of State had acted unlawfully on procedural fairness grounds, and because the Secretary of State was alleging dishonesty and they hadn't followed the principles set out in Balajigari. Now, I've set out that aspect of the judgment because I think it's so important. And in a load of cases this year, Balajigari principles have been in the forefront. So really important. both in sponsor license and in other cases, that where there's an allegation of dishonesty, there's no burden on the sponsor to prove it. If the Secretary of State has a suspicion that the sponsor has acted dishonesty, she must indicate to the sponsor that she has that suspicion and give them the opportunity to respond. Then, having received representations, the Secretary of State must consider all of the relevant circumstances before deciding there's dishonesty. And when deciding there's dishonesty, paragraph 136, the Secretary of State needs to give proper reasons for that. So really helpful Balajigari principles set out and applied in the sponsor license context there. Similarly, TJ Trading Express, a decision of the Administrative Court from Mrs. Justice Hill, that was somebody who employed a family member, a brother-in-law, for the role of petrol station manager, sponsor license revoked on the basis that the vacancy was not genuine. The claim succeeded both on procedural fairness grounds and on the basis that the Secretary of State had erred in her approach to whether there was a genuine vacancy. And the judge found the Secretary of State had not asked herself the correct question, stating that, and she said that there was no evidence that the decision maker had asked the correct question, namely whether there was any evidence of the sponsor having acted deliberately or dishonestly. And she also found the decision was inadequately reasoned. So again, a helpful decision there, again, applying those Balajigari type principles. And a recent successful, it's a care agency, in this case, Trial Care. They had 75 sponsored workers. Ultimately, their license was revoked on the basis that 3 of the 75 had not been paid the correct salary. And as a result of the salary issue, it led the Secretary of State to find there wasn't a genuine vacancy. Again, it was successful in this case. Let me just read you something in relation to the employees. Employee 1 had taken unpaid leave, and the Home Office decision maker, even though Trial had informed the Home Office of this, had failed to adjust the annualised salary accordingly. So the decision was flawed in relation to Employee 1. Employee 2 underwent training for a number of months, and there were payroll discrepancies, but Trial had made a back payment, and again, the Home Office didn't factor that in when considering the salary. Trial had got it wrong in relation to Employee 3 because Employee 3 took compassionate leave. Trial thought they could reduce the pay for him. They were wrong in relation to that, but there was no evidence they'd acted dishonestly in doing that, and there was no evidence that these vacancies were not genuine. I've set out extracts from the judgment here, which will be helpful to you. And again, if the decision letter was alleging dishonesty, there had been a failure in terms of a Balajigari there. So again, helpful decision in Trial. I've covered in previous webinars about Andrews back from the beginning of the year. This was the person who was on a health and care visa working in a friend's store. Her visa then was cancelled. Interestingly, the store owner said to the civil penalty compliance team the claimant was a volunteer and had a no action notice issued against them. Andrews argued that the guidance allowed her to do voluntary work. The problem is voluntary work is defined in the immigration rules, and that applies the National Minimum Wage Act, Section 44, and she wasn't working in accordance with that, so her claim failed. So really important with clients to watch in terms of both supplemental employment and voluntary work, that they are complying with their visa requirements. We saw a number of cases in January this year clarifying the approach of deprivation of citizenship. Probably the most important was the case of Chowdhury. Following Begum in the Supreme Court, the approach to deprivation appeals had changed and the courts have adopted more of a review approach. See the upper tribunal guidance in cases like Cesari and Chimmy. But Chowdhury, the Secretary of State actually changed their mind and said, well, actually, we say now that Begum, there was a different approach. There should be a different approach to deprivation where the allegation is fraud as opposed to conducive to the public good. And therefore it was accepted, and the Court of Appeal accepted, that it is for the tribunal to make a finding of fact about whether there'd been fraud, false representation, or concealment of a material fact, and all evidence, including post-decision evidence, can be considered. There is this additional element now, the causation element, that is reviewed on public law principles, and the discretion issues also on public law principles. And then in the human rights assessment, it is again for the court to decide. A presidential panel of the upper tribunal has followed this now, so it's simply set out in the recent upper tribunal decision of Latchi, where again it sets out the first, second, third, and fourth questions to be considered. So if you're doing an ASA, that's the way to frame your schedule of issues in a deprivation case where the allegation is fraud. You've got the precedent, fact, causation, discretion, human rights. The second case from the Court of Appeal in January on the 17th was Colici. This was the Secretary of State's policy of serving the notice of intention and the deprivation notice pretty much together. In fact, in Colici, they were done within 30 minutes. So he was deprived of the opportunity to make representations before he was deprived. The Secretary of State had this policy, which apparently wasn't written down anywhere, to do this, to stop people renouncing any other nationalities. And Lord Justice Underhill there, you can see where he says the Secretary of State's action was unfair. And again, there's reference to Balajagari there at paragraph 43 of Colici. The final case was Daci. Daci had been allowed in the first tier tribunal on the finding that there hadn't been fraud. The upper tribunal had set that aside, but allowed the appeal, saying the Secretary of State had failed to exercise her discretion properly. The Court of Appeal disagreed with the upper tribunal, but the case was remitted back because Article 8 hadn't been dealt with. And I think it's an important reminder for practitioners that when arguing deprivation of citizenship cases, don't forget to argue Article 8. Although remember the limited and different focus of Article 8 within a deprivation appeal context. And I've given you some Court of Appeal references there of the differing approach to Article 8 in a deprivation case, the different focus rather, but it's not a case of removal. Just some protection cases quickly. I'm conscious of time. If you're arguing, or the Secretary of State is arguing, to depart from a country guidance case, obviously look at paragraph 57, there needs to be shown very strong grounds supported by cogent evidence to justify it. Now, in SB Sri Lanka, the upper tribunal had departed from the case of LH and IP, but the Court of Appeal found that what the upper tribunal judge there had done is he'd engaged with the material before him, but not looked at the material which was before the tribunal in the country guidance case, and that should have been analysed to see if there were these very strong grounds supported by cogent evidence for not following the country guidance case. So if that's relevant to you, have a look at PG. ASJ Somalia from March deals with the test for internal relocation. Obviously, remember in post-NABA cases, the differing approach to standards of proof. Have a look at the upper tribunal reported case of JCK in relation to that. But this reiterates the test set out in Januzzi and AH Sudan. So have a look at that, and also ASC Jamaica. In terms of burden of proof, ultimately it's probably on the appellant, paragraph 41. But in essence, questions of burden of proof are not going to influence an assessment of internal relocation. It's for the decision maker to decide on all the circumstances whether it would be unduly harsh. Have a look at that in relation to internal relocation. A lot of asylum cases I'm dealing with at the moment have surplus activity, particularly say Iranians, Iraqis, or Bangladeshis. MH Bangladesh says, look, tribunal mustn't impose an unrealistic evidential burden for those who rely on surplus activities. They're not going to be able to adduce evidence of surveillance by the foreign state. And they quote helpfully from WAS Pakistan, and noting the ease in which demonstrations can be filmed and photographed, and that can be transmitted abroad. What I think an applicant will need to provide, paragraph 40, is evidence of news media coverage. So if there's a demonstration against the Iraqi government that's then in the UK that's reported back in Iraq, you can show, look, these things are monitored and they're getting reported back in the home state. So that's the sort of evidence you need to provide, paragraph 40. Article 8, Well, but is the final nail in the coffin of Chikwamba. Lady Justice Elizabeth Lang confirms that it's only in cases where the Secretary of State expressly refuses leave to remain on this narrow procedural ground that the applicant must leave the United Kingdom and apply for entry clearance that Chikwamba is going to apply. And even then, it's necessary for a full Article 8 assessment. And it doesn't apply even if in substance the decision is a requirement to leave the UK and apply for entry clearance. Arshad is about the nature of family life. Just because there's family life is only a starting point. You have to look at the nature and quality of the relationship. So it's important to argue that before that can be weighed against other considerations. And in terms of the other side of the balance, there's a range of what is precarious leave. So be careful to argue family life specifically and address your client's status so the balance can be conducted properly. Tomlinson is a very sad case about where he'd succeeded in a revocation of a deportation order appeal, but then entry clearance was refused. The upper tribunal refused JR, arguing on a number of grounds, including that there was an alternative remedy because he had an appeal. The Court of Appeal disagreed with that and effectively said, well, look, matters were resolved by him winning his revocation of the deportation order. And they said an appeal wouldn't have been an alternative remedy, so JR was appropriate. But sadly, his wife passed away after giving birth to their son. So the court refused to make a declaration that he was entitled to entry clearance. So really salutary reminder of the important issues we're dealing with in cases such as this. I've given you an update on the good character judicial review from Wilson Solicitors. Thanks to them for that. We're waiting a decision on permission on the papers. But if you are interested in the good character guidance change and you're advising clients whether to make applications who entered unlawfully, have a look at that. And that's helpful for you to update your clients on what to do with the change in policy from February of this year. We often argue the need for anxious scrutiny. Mr. Justice Fordham in the Alnor case has given some really helpful guidance as to what is anxious scrutiny. So I would encourage you to look at that. And what I've highlighted, this was a case, an NRM challenge, refusal of a reasonable grounds decision. Client has subsequently got refugee status. Fordham finds that that doesn't render the NRM challenge academic and gives some really helpful guidance on what anxious scrutiny is. I've set out there. So if you're arguing the Secretary of State hasn't approached a case with anxious scrutiny, have a look at that and you may be able to draw in your pre-action letter or your JR grounds from that. It's 1 minute to go and I've got to EUSS case law. Let's just give you some headlines. This is about Zambrano people and the case of Ahmad, who applied before the 31st of December. Decided after that, the Secretary of State argued there was no power to issue an EEA family permit. The Court of Appeal disagreed. In Borges, if you're going to rely on the 10 years imperative grounds of public security, you can only rely on your time as a European national. You can't combine your time as a third country national and, in this case, a Portuguese national, which Borges tried to do. But Lady Justice Elizabeth Lang found that was wrong. Mustaj deals with this terrible drafting in Appendix EU and the definition of a durable partner in this case, and the definition in AAA, what the upper tribunal said in Hani. The revised version in AAA had not introduced a degree of clarity, but actually introduced a drafting error into the rules, which Lady Justice Falk corrected. And the revised and original form of AAA is confined to those who had another lawful basis of stay. Heavy stuff there. If you want your head to hurt, have a look at that if you're interested, because Lord Justice Underhill was very critical of the drafting of Appendix EU. It's 2 o'clock, so let me just flag up to you some important latest upper tribunal reported decisions on withdrawal of decisions, on stay under the Trafficking Convention, on the drafting of grounds, of costs in judicial review claims, and also on evidential flexibility and administrative review. Here's the case which I was involved in on drafting of grounds. I've highlighted the relevant section. If you're drafting permission to appeal grounds, that's how you should frame it. And this case, really important on evidential flexibility, and the policy now applies to all routes under the immigration rules except FM and protection routes. It's no longer just applicable under the points-based system. And also there's some guidance on in what circumstances is additional evidence admissible in an administrative review, because normally administrative review is generally on the evidence that was before the original decision maker. Very recent case of Bitar. What we're seeing now is salaried judges doing their own PTA application. So if a judge refuses your appeal, you challenge her. If she's a full-time judge, it'll probably go before her. And in this case, Judge Plimmer, who's the new vice president of the upper tribunal, found that doesn't offend against procedural fairness and does not give rise to concerns of bias. So that's a practice now we're going to see go on. Guerrero is to do with excluded decisions, and a judicial decision to treat an appeal as abandoned is not an excluded decision, and the upper tribunal does have jurisdiction, and there's consideration here of the excluded decisions order. I apologise, I am 2 minutes over. Here's the link to get my resources. Come to my live event if you've got questions, and we can go through all this in a lot more detail and with a lot more time. But thank you for giving up your lunchtime. Thank you for coming back to school. And thanks, Finn. Over to you, mate.
Thank you so much, Adam, and thank you to everyone for joining us today. As a reminder, the slides and a recording of the webinar will be sent over tomorrow. And this afternoon, you should receive an email asking you to rate the webinar out of 5 stars. If you have enjoyed it, please do leave feedback and any suggestions for future topics. Our series of webinars continues next week on Thursday, the 11th of September at 1 till 2 p.m, when we will be presenting a webinar on process serving for lawyers by Greg Gillespie from Legal Connect. Thank you very much, everyone, and have a good afternoon.
Thanks, everyone.
Cheers, Adam.